My name is Torben Brody, and I'm sometimes at this university, and it's my big pleasure to open this panel on international law and economic crisis, which I think this was the moment when Yuval was as the architect of the program, and anything that seemed to have something economic in it got siloed into, as often happens to the international economic legal academia. But the papers are diverse. They do cover a broad range of issues, sometimes even question whether they are economic or related to economic crisis, but we'll get to that. The way we're going to do the panel is that you present in succession, and then we hear comments from Anne Van Aken as commentator, and then we'll open the floor to discussion. I just think ultimately it's more effective, especially since I'm sure Anne has lots of comments that we'll be able to push the discussion forward with the audience. So really, without further ado, Sandra Hoffer from University of Ghent. Please, on sanctions.
Yeah, on sanctions. So, you hate sanctions. Yeah, well, there's many people who would agree with you on that. So I guess the reason that I'm in this panel is because it's sanctions, and so anything economic sanctions and then economic crisis. But I'm not going to talk about economic sanctions, from an economic perspective. I'm actually going to look at them from the perspective of the role that they play within the international legal order. And as that is already a heavily contested concept, I want to say, what do they tell us about the international legal order? So usually economic sanctions within this order, they're supposed to play a coercive function. So we accept them half-heartedly within our system because they're the only means available for us to enforce international law. And we have seen a rise in state practice, especially with the United States and the European Union, who are more and more frequently adopting sanctions in response to, in order to quote this forum's title, to situations of disorder abroad. Usually this disorder is caused by human rights violations or political crises in another country. So that raises a whole set of questions in international law because already if you want to put things in categories, you're wondering, well, what is this practice in legal terms? So you could approach that issue from a legality perspective, but I'm going to look at it from the effectiveness perspective. And effectiveness can be defined in two ways. So I'm not going to look at effectiveness in terms of whether or not these sanctions are successful at achieving the stated policy aim, but I'm interested in effectiveness in the sense of what is the effect of the sanction on the construction of the legal order, and what is the effect of the sanction if we zoom in on the target state. And I approach sanctions then not from their coercive perspective or their coercive function, but from their signaling effect. So before, there's been this rising political science on what is actually the utility of sanctions, and so now in political science we're seeing that sanctions serve a variety of functions, and one of them is sanctions signaling effect, which can also be understood as stigmatization. So basically when you sanction another state, you're saying that they're wrong, that their behavior is not in accordance with the expected behavior from a member of the international community. So stigmatization is a response to norm-breaking behavior, and it helps members of the international society distinguish good behavior from bad behavior. So stigmatization has a communicative function. And there has been an article that's frequently cited by Rebecca Alden-Nissen. It was published in an international organization in 2014. And she said that if we want to understand how norms work and how norms are created within a society, look at stigmatization. Because processes of stigma define the boundaries of the norm. And there's also been work by Zadikol on the fact that it's not socialization really that helps society stay together and that helps construct norms, but it's stigmatization. Because you can only stigmatize someone if they're incorporated within the same social world as you, and if they understand the norms that you are trying to impose on them. Because stigmatization will have no effect on, if you tell someone you're wrong, and the person isn't within the same framework or the same mindset as you, they will not understand what it means to be told that they're wrong. So this means that non-compliance doesn't always mean a lack of socialization. It can actually mean hyper-socialization. You're very much aware of where the norm comes from. And it's not that you dispute the norm, but you dispute the source or the hierarchy of the norm that is being imposed on you. So it is approaching sanctions from this perspective, from the perspective of stigmatization, that I want to explore, that I wanted to explore in this paper. So I'm also interested in stigma and sanctions as a form of interaction, because the state that is imposing the stigma is acting as, and also the group of states, they're acting as the audience of normals. They're giving themselves the right to say, well, we are the enforcers. It is our responsibility to use our economic power in response to these crisis situations and in order to uphold the fundamental values that we want to protect in our international relations. So if you just end it there, where you think, oh, well, it's quite simple, I adopt a sanction, I stigmatize, the norm is upheld. However, since it's an interaction, so the act of a sanction is, an action, and it will trigger a response from the target or from, the group that feels targeted. And my argument is that if we look at it from a process of interaction, we can look at it from two ways. So we can start at the level of the international legal order, and we can observe that it is heavily contested, this process of stigmatization. So even though there is a group of states, essentially the United States, the European Union, but then their allies, Canada, Australia, the European countries that have restrictive measures, etc., that adopt these sanctions, there's also, on the other side of the spectrum, groups that are comprised of the G77, the non-aligned movement, and then you have Russia, China, BRICS states, and other regional groups that contest the adoption of unilateral coercive measures. So inasmuch as the process of stigmatization signals which norms one group of states should be upheld within the international order, when states contest the adoption of unilateral coercive measures, they're also making a normative claim. Now the problem is, in both parts, is what do you mean by norm? Because here this is like a policy, an international relations perspective, and in international relations, norms are usually understood within the social sense. This is one of the weaknesses so far, or like the gray areas of the papers, like what is actually the legal content of the norms that they're trying to uphold, and on both sides of the spectrum. Because in the EU and in the US, they'll refer to democratic principles. But then that leads to a whole question of, well, what is the legal content? Is there a right to democracy? What is the actual norms that you're trying to uphold? And generally speaking, this points towards the rights that we can see in the International Covenant on Civil and Political Rights, if we had to look for a treaty or a conventional source of the norms. And on the other side of the spectrum, those that contest the adoption of sanctions refer to, in very broad terms, peaceful settlement of disputes mechanisms, the UN Charter. And so basically they criticize the fact that these unilateral coercive measures undermine the multilateral order they wish to uphold. Now what I find interesting is that they do not contest the validity of the norms that the other states want to uphold, but they seem to be very critical of the means of enforcement that is being used. So I think that might provide an interesting clue. It's something I have to investigate further. Maybe, despite appearances, there would be a normative foundation upon which the so-called international legal order can be built, but it's practices of stigmatization and contestation that kind of tear that fabric together and make it appear really as if there's a fragmented international legal order, as each state and each group of state is defending its own understanding of the values that should be at the basis of this international legal order. And so what I found very interesting is that within both groups, if you look, for example, at the states that adopt the sanctions, and you look at their discourse and the justifications they give, as a collective, they refer to themselves as like-minded, as partners, as allies, and they really emphasize the fact that it's their responsibility, or they're to uphold these norms. So from a sociological approach, it kind of looks like these groups are defining themselves sort of as a subculture where there's different social expectations. So then those social expectations imply a certain set of norms and values and practices that they should uphold as a collective. And you see an interesting mirroring of that on the other side. So whereas the other states say, well, it's our responsibility to act collectively in order to enforce these norms, on the other side of the spectrum, groups such as the Non-Aligned Movement and the G77, they say that they want to act in solidarity with groups, with states that are the target of unilateral coercive measures. So, for example, Zimbabwe, Venezuela, Belarus, and Syria, and that they engage to not adopt unilateral coercive measures against members of these groups. That's interesting because on another side, we see, and I didn't get into it in this paper, and I'm not going to get into here, but I'm just going to mention it, is that there's regional organizations that adopt what we would call multilateral sanctions. So sanctions by the regional organization against a member state that has accepted the constitutive act. So they've accepted that regional organization's authority to impose sanctions on them. So that might point to, something that could be accepted in terms of sanctions or in terms of enforcement. But what seems clear to me is that they do not accept the fact that it's an outside authority that comes in and that tells them how they should behave or how they should not behave. So what we really have is this divide between unilateral practice on the one hand and this desire to defend the multilateral legal order. And I believe that it's really the idea that it's states that are setting themselves above, like this kind of moral authority that is placed upon them, and that they are resisting and contesting. And I don't know how I'm doing on time.
3 minutes.
3 minutes. Okay, so I really got into the international legal order part and how it produces contestation and a fragmented legal order. I will not get into the other spectrum of the paper. Is I look into the effect it has on the targeted state, and my argument there is that it creates a dispute between the sending states and the targets. And this is clear, I think, if we just look at the situation between Russia and the United States and the EU, especially between Russia and the US, it's incredibly tense, and I think that a lot of it originates back into the Ukrainian crisis and the West's response to this crisis. So even though we would say that from the international law perspective, the aims of these states are legitimate, for Russia, it's framed as punishment. We're not being sanctioned for what we did. We're being sanctioned for who we are. This is a policy of containment. This is just practices of the Cold War. So, they frame it in that way, and they indicate the fact that they're resisting the label that's being placed on them. And just to mention very quickly as well, you can observe this practice of resistance if we look in Venezuela. So there as well, it's a dispute between, the US especially is the one that started adopting sanctions in 2015, and now Canada and the EU followed suit, and Venezuela reacted by declaring the Canadian and Spanish ambassadors persona non grata. And if you look at Venezuelan speech acts, they really refer to the US as the imperial power, the capitalist state who is trying to push the Venezuelan economy into a default, and that they're actually being punished because they're a socialist economy. And in that way, they also align themselves with Cuba. And they say, well, look how they treated Cuba And they actually seem to take pride in the fact that they're being stigmatized and they are being positioned as the enemy of the U.S. And so these two states, Russia and Venezuela, as they seek to counter the stigma that's imposed upon them, they seek to stigmatize the sanctioning states by emphasizing the fact that they are violating international law when they adopt sanctions, and they refer to their own audience of normals, which is constituted of the groups I was referring before, the G77, the NAM, and that group of states. So, the title of my presentation was Reconsidering International Law's Enforcement in Times of Disorder and Contestation. And my argument is that despite the fact that unilateral coercive measures are what we have really, our safety net in terms of enforcement, my argument is it's counterproductive and it leads to fragmentation. And even though, like, I personally don't have an opinion on whether fragmentation is good or bad, but given the fact that it creates further disputes and tensions and doesn't seem to have the influence on the target that we would hope, that we should consider other means of enforcement. And so that's the future challenge as I go into the final leg of my PhD, is coming up with something that even at first it might appear as a vision and idealistic, that maybe one day it will become something real. So creating an alternative reality that maybe one day will be grounded on this. Yeah, in our new order. I don't know. So that on that idealistic note, thank you.
Perfect time. Thank you very much. Now from the hard world of sanctions to probably as soft as it can get, the World Development Report, and also one of the nicest titles on the program, right? Stabilizers, Seductress, Servant. It sounds like a work of fiction. Please, Liz Kurmadev from Ashi Engineering.
Great, thank you very much, and thank you all for coming. What I'm going to do in the next 10 minutes or so is that I'll first start talking about what drove me to write this paper, even though my work is on the resource curse, so very far away from what I'm presenting here. Then I'll give you a very brief summary of this paper, and then try to situate it in the broader framework of this conference. So, as a high school student in Germany, I grew up with the idea that international law was a force of mobilization in the context of the protests against the illegality of the Iraq War. That was the tool that we would write it on our posters. It's an illegal war. And that phenomenon around the world led Philip Sands to observe that this was the moment when international law went public. So from that particular experience, I observed with lots and lots of concern, with almost fear, how the discourse in Germany, but also around the world, changed around what I, as an internationalist, hold dear. As you observed yesterday, it is my liberal order. So I saw the protests, the rise of national movements. I saw the contestation around refugees, and I started to think a bit. That's when I felt that I needed to theorize this, because I couldn't really make sense of it. I didn't understand what was going on and where my concerns came from. So that's when I started looking at contemporary social movements and how they used law. This as a broader setting. So now to come to my paper. I take the World Development Report on Governance as the Law as an example for how I think an institution of the liberal institutional order, so not liberal order, but liberal institutional order, is reacting to contestation posed by populist economic nationalism. I don't say that this is for sure that the moment that triggered this report was only the rise of populist economic nationalism, but I think it's plausible that this would be one of the contributing factors. And then I go through different strategies, or I go through different possibilities why it would make sense to use international law in a particular way, referring in particular to the way that the world talks about socio-economic rights and the rule of law. So together, I argue that socioeconomic rights and the rule of law and how they're used in this development report, and how the inclusion of socioeconomic rights by the World Bank is promoted in domestic constitutions. I argue that, in a sense, they make use of international law as in Joanne's understanding welfare international law. So that something that seems to be missing, or something that a lot of social movements around the world seem to be missing from the contemporary structuring or the contemporary order in which we all live in, that there's actually an answer to that, and that is the answer is also embedded in international law. In doing so, I argue that international law serves has a threefold purpose. So for once, it is the ideology of liberalism, or liberalism as an ideology is ingrained in international law. By referring to the Neo-Gramscian and the Hardy-Negri concept of hegemony, I say that it can be strategic to stabilize a particular form of structuring. And finally, I say that, in particular, given the contestation around the promises of economic globalization, that in fact, since that narrative seems to be challenged all the time, that international law may actually emerge in parallel as a narrative to why globalization in itself is actually not such an evil thing as it is made out to be. So this was the summary in very broad brushes. So maybe just to situate it in the broader framework of the research forum, because I realized that for most, in contrast to many other presentations that we've heard before, I'm not talking about the typical institutions, and I'm also not really going and using the typical tools, and possibly doing everything that Vishak cautioned us not to do. But I still think that as an international lawyers, we have something, we are more attentive to how international law gets used or misused than maybe other disciplines would be, and that we shouldn't be refraining from saying that or using that as a tool of analysis. So thank you very much.
And now we'll move to Vladislav Janic, University of Amsterdam. It's investment law.
Thank you. So I'll be talking about the governance role of international investment law. How do I control the slides?
There should be a remote control.
Most I like the photo of Amsterdam that I chose. Like,
Yeah.
I think.
Maybe I can use slides.
Can you see?
Yeah, perfect. I'm not that tall, so.
Thank you. How does it? Okay.
Is it working?
Yeah, it doesn't switch.
I can do it.
Okay. So we have heard a lot at this research forum about contestation and backlash. Maybe I'm a bit biased, but I think that in terms of areas of international law that have been under fire, international investment law is right up there as one of the most topical and kind of the one has received the forefront of the backlash recently. One of the main reasons behind this backlash has been the realization that what investment treaty tribunals do is not mere resolution of private disputes, but they actually have a significant impact on how governments can regulate in the public interest. The current perspective on this newly recognized rules is that this is something that is a radical departure from previous practice, something that we haven't really seen before. In my paper, I tried to offer a somewhat different perspective by looking at the governance impact of some of the arbitration tribunals that resolved disputes between foreign investors and states from the early 20th century. So I hope that that would give a sort of better setting for understanding what is going on today. In going about this, so I'll first try to explain the role of governance in investment treaty operation today. Then I will look at two historical examples of past tribunals exercising similar governance roles. And then finally, I will look into the implications of this for our understanding of this concept. Can you switch? So the issues that are put before investment treaty tribunals often involve issues that go to the very core of public interests, such as human rights, the protection of the environment, or the protection of public health, and other interests as well. In resolving these disputes, investment tribunals are often tasked with interpreting laws of general application, which means that in essence, these disputes can be termed as regulatory disputes, and they are in great part alike and comparable to a form of administrative or constitutional review. Now, when investment tribunals exercise this type of review, they do so on the basis of international investment agreements that contain standards of protection that are often very similar, yet at the same time open-ended. So what this means is that instead of simply sort of applying the law to the facts, in effect, the tribunals are actually giving significant content to the very standards of protection they are supposed to apply. Now, considering that investment tribunals often have a tendency to look to the decisions of previous tribunals, not in a binding manner, but yeah, almost every decision has a considerable engagement with decisions of past tribunals. So, in essence, can you search this? So, essentially, they have a significant impact on how future investment disputes are resolved between parties that are not necessarily the parties to the dispute they're resolving. So, in this sense, they are basically setting out standards for assessing whether government policies are compliant with their international obligation, and through this they exercise a significant governance role. Now, this role has mostly been seen as something that is a rather extraordinary and novel development. For example, one of the sort of main critics of international investment law has described this power of tribunals as newfound and revolutionary. So in my paper, I tried to argue that such a characterization is perhaps not fitting, and I tried to do this by offering several examples of past investment tribunals and the governance effects that their decision had. Yeah, perfect. So in this regard, I will talk about two cases today. The first one is an arbitration between the Administration of Posts and Telegraphs of Czechoslovakia and the Radio Corporation of America, which was a case that happened in the 1930s. The dispute in the case arose in relation to a traffic agreement for establishing a direct radio telegraphic service between Czechoslovakia and the United States of America. Now, soon after this agreement was signed, the administration notified the Radio Corporation of America that it was intending to sign another agreement for a similar circuit with one of the corporation's biggest competitors, because it thought that the traffic between the two countries was not significant enough and it wanted to increase it. Obviously, the Radio Corporation of America did not like this and argued that the administration did not have the right to conclude such an agreement, and eventually the dispute was submitted to arbitration. The tribunal was tasked with determining whether the administration's intent to conclude such an agreement was in line with the traffic agreement concluded between the two parties. Ultimately, the tribunal found in favor of Radio Corporation of America, deciding that the traffic agreement prevented Czechoslovakia from establishing a second direct radio circuit. Thanks. So, in looking at the actual pronouncement of the tribunal, it said the administration of Post and Telegraphs has not the right to establish a second radio telegraphic service between Czechoslovakia and the USA. So, as we see from this, the tribunal basically directly decided on the right of a state administration to take action aimed at providing a public utility for its citizens. What is perhaps even more interesting is that, in fact, Czechoslovakia complied with the decision of the tribunal and did not conclude the second traffic agreement, even though there was a need for it in terms of the need to increase communication between itself and the United States of America. So in this sense, the tribunal's decision had a very significant impact on the level of telecommunication services that were provided to Czechoslovakian citizens. So the other example that I want to address is an arbitration that happened between the DAF Development Company and the government of Kelantan in 1916. And this concerned the construction of a railway through the territory that the company held under a concession. Now, the initial concession that the company had provided for very extensive rights, which also provided for the exclusive right for railway communication through the territory. This initial concession was soon thereafter modified, with the company receiving a more limited set of rights in exchange for cash consideration. The problem arose when the company interpreted this modified concession as obliging the government to construct the railway through a specific route through its territory that would be favorable to the company. Of course, the government disagreed on this, and again, the dispute was referred to arbitration. The sole arbitrator, whose decision was very short and not reasoned, ruled in favor of Kelantan, finding that the government had in fact not yet decided on the route and that it was free to choose the railway route as it saw fit. Now, obviously, in comparison to the Radio Corporation of America case, here the arbitrator did not impose any obligations upon the government. However, the arbitration still demonstrates the considerable governance potential of the arbitration proceeding, considering the arbitrator did consider whether or not the government was allowed to consider a specific route of the railway. This is particularly so considering that actually the government had stopped constructing the alternative route of the railway when the arbitration was initiated, while it was waiting for the decision of the arbitrator. So essentially, the government of Kelantan recognized that the decision of the arbitrator would impact the route of the railway that would be chosen. So these two cases are by no means sort of historical anomalies that float there by themselves. There are other similar examples of arbitral tribunals making decisions of similar and comparable impact. For example, tribunals deciding on the implementation of social contribution schemes, deciding how railways would be reorganized, who was to operate the national telephone system, or prescribing safety regulations for workers. So, as we can see, and as I try to show in the paper, it was not at all exceptional for past investment tribunals to have quite substantial governance impact. So, what does this all mean? I submit that there are two sort of major implications from these past cases. The first is that it influences whether or not we perceive what is going on currently in investment treaty arbitration as some kind of radical, extraordinary development, as the historical record seems to indicate that this phenomenon is perhaps not as unique and not as novel as was maybe thought, which is definitely a relevant factor in assessing its legitimacy. Now, by this, I of course don't mean to imply that the sole fact that this has been going on for some time means that it's legitimate. Of course, it is not. However, at the same time, I think the way sort of the discussion has been framed so far has kind of undermined the legitimacy of this concept solely by associating with this sort of radical, unprecedented development. And I think it is better to have, because I think that the phenomenon raises enough legitimacy concerns on its own that it doesn't need to be associated with such branding when those problems are discussed. The second implication concerns the need for a more nuanced understanding of what governance is. So the historical cases that I have discussed, I think, indicate that not all governance is created equal, and that it is in fact possible to differentiate between the different degrees and different types of governance. So, in essence, there is room, I think, for understanding governance as a polysemic or multifaceted concept. And in this regard, I think so what I try to show is that the past investment tribunals had a much more direct and immediate governance effect, in a sense, by directly prescribing the course of action that was going to be taken in matters of public importance. On the other hand, when we're talking about governance investment treaty arbitration, that is a much more indirect form of governance, because basically what we're talking about here is tribunals creating rules according to which the legality of direct exercise of governance is going to be evaluated. So it is basically the governance role of investment treaty tribunals is more akin to making the rules of general application that regulate the exercise of governments, or in essence, it is the governance of governance, or what I term here meta-governance. So compared to the direct or immediate governance role of past tribunals, this is a much sort of weaker or indirect form of governance, which at the same time, of course, doesn't mean that it's less problematic or important, especially considering the scope, which is unprecedented, I think, and considering the global reach that these decisions have today, which was not the case to that extent in relation to the decision of past tribunals. So, in conclusion, investment treaty arbitration, I think, for sure has been a game changer, but I think that it is not an entirely different game. There is still certainly much work that needs to be done in figuring out what is the new problematic aspects that arise as a result of these developments and how they should be addressed. I believe that in this, proper historical contextualization can provide invaluable guidance by freeing us from preconceived notions regarding this phenomenon and helping tease out what are the most pressing issues and what are the issues that are actually sort of specific and idiosyncratic of this phenomenon, and then how these issues can be identified and addressed.
Only.
There's the coffee break afterwards.
Okay, I tried to be quick and I would go in the same order. And let me say that I enjoyed reading all three papers immensely, and especially, but I'm going to come to that, the investment paper, because usually I thought, I'm so bored reading investment papers by now. But I wasn't bored by reading this one. But let me first turn to Alexandra. And Alexandra knows that I'm reading her paper not unbiased, because I like her work, and I know within which frame you're arguing. And let me also say, and I know you had few time to prepare the papers, that your talk, I think, was clearer than the paper.
Yeah,
so
okay.
take some of the remarks with a grain of salt.
Yeah, of course.
So I think what you do is really combining a very pressing issue in international law, the decentralized sanctions, with the theory to understand their functioning. And that's my very first point, the theory. I think you need to somehow, and I know you come from the constructivist school rather more, but you're not so clear when you situate yourself, and you don't necessarily need to. But I think that it might make sense to be clearer in the introduction where you situate your discussion and what exactly is the research question, and tackle it out with from what has been there in the research on decentralized sanctioning. So I guess you would need to add a section on probably IR theory. What are the prevailing theories and how we deal with decentralized sanctions, including their effectiveness, and all. But you can make copy paste from your other papers. I think I would be more cautious in that section on an all or nothing approach, but because by now you sort of try to explain with the stigmatization theory, which, by the way, you still have to spell out more. But of course, this is just one aspect when we want to understand this the effectiveness of decentralized sanctioning. So I think still what we have hitherto, like a more rationalist approach to that, is the cost-benefit analysis, and it's still valid in a way because we still impose material costs. And you are basically looking at additional costs, right? And this remark is with a caveat. And I'm going to come back to that in a second. I will also be clearer on, like when you define the costs of sanctioning, on whom exactly you mean. So the target state, the targeted state, third states. Within the targeted state, and I think that is very important for your theory, the different actors. Because one is the government and the other one is the opposition, which might be, for example, in opposition of the international law violating act which has been taking place, and might use the international sanctioning in order to combat the government. So I don't think you can understand or you can apply the theory of stigmatization without breaking up the black box, at least in the targeted state, if not in the other states. So I wonder, and it comes back to the research question, when you look at the effectiveness, so traditionally you have more the economic costs and all that stuff, so you go on to the stigma problem, and then there are two functions here. One is the punishment. You want to punish the state. That's repressive. But I think what you are really looking at is the preventive function, the upholding of the rule of law. So you're looking at the role of decentralized sanctioning in upholding the rule of law, the rule of international law. But I'm not sure that I understood that correctly, but that might be that you need to kind of disentangle those two functions of the sanction. Because the contestation of the targeted state can go both ways, right? They can say, well, the norm is not valid, or we didn't do it, or, they're, like we had that before in the last panel, on the facts and the norms. You can contest on both.
Yeah, so...
So just, I would be clearer on that one. So what I would think how you could proceed is really have a more theoretical part, and then zoom in on what you want to do on that part of explaining sanctions, and then on the, as you said, you where you want to go is to try to find a system where we can use decentralized sanctioning as a legitimate system in international law. And you might want to look at the fair sanctioning literature in what I'm going to say, in behavioral economics and in game theory, because we know that it's important that sanctions are perceived as fair, otherwise the system is destroyed. So you might want to use that a little bit.
Yeah.
Okay, since I have only 10 minutes, how many do I have left?
You have to allocate equal time to each one of the papers. You're opening.
So let me come to the stabilizer, servant, and seductress. Again, I very much enjoyed reading the paper, and as you said, it's not a topic which is much analyzed, so that's much appreciated. I wasn't totally sure what the status of the paper is. Is it descriptive? Is it explanatory? Is it critical? I wasn't sure about that. And then again, I think you're in a way have separate points which I would analyze separately. Concerning the role or the strategies of the World Bank. I think first remark is there any literature out there on strategies of the World Bank and adaptation of the World Bank to its critiques? And I think that's there. I mean, even if you talk about the inspection panel, there has been, that was also a reaction. The issue of rule of law and the socio-economic rights equality/equality. And it seems to me that you're somehow mixing this. So, not mixing, it is mixed de facto. And I give you a story. In the middle of the 90s, the World Bank under Wolfensohn started combating corruption. And before, they just paid their money, you had bridges to nowhere built and nice palaces in the country of Switzerland, and the World Bank kept paying. And then they said, we have a problem here. So maybe we should be talking about corruption, which is a heavily internal system issue of governance. So they turned to the rule of law. Why is that? Corruption, and let me say that, and I'm saying this because it has to do with socioeconomic rights. If you look at studies about corruption, effects and consequences, well, what's the main consequence of corruption? Inequality, access to healthcare, access to education. It's totally unequal the more corrupt a country is. So combating corruption is, since the 90s, is at the same time combating inequality. So I'm a bit, I think you have to be much more careful on the strategy. Now, when you look at, and you didn't cite him at all, and I was astonished about this, Sciatta, as the General Counsel of the World Bank for many years, he has good arguments why the World Bank was somehow prohibited of going officially into human rights, because that was deemed to be a political issue of the member countries, and the World Bank was not meant to mingle into this. So they invented again rule of law, as an indirect means. So I think you somehow need to be more clear what is different now. Is it really just the explicit turn to socioeconomic rights? And then again, the question is, do they have the mandate? Because the mandate has not essentially changed. So why can they suddenly do this? Whereas Sciatta always said, no, we can't. So I think those are issues you need to tackle. The second thing is that, I know that's a very terrible economist's remark. I wonder about, it's plausible what you say. They turn to socioeconomic rights and inequality because they feel they are under threat. And they're anti-populist movements. But then, as an economist, I would say, well, there might be some omitted variables here. One omitted variable might be the SDGs. The World Bank has explicitly committed to the SDGs, as all other international economic institutions, including the WTO, but of course the IMF. So, how can you not say that those are the explanatory variables explaining the new strategy? So, to conclude, 2 main points. Is it really a new strategy of the World Bank, or is it just in new clothes? It's all wine in, new bottles, right? And second, what are other possible explanatory variables? Third, paper on investment. As I said, I rarely read something new in investment law, so I much appreciate that. And I think your case selection is very good. What I missed, a lot of the paper is cases. They're very interesting. I didn't know them. But I missed the theory and the structure. So I think, indirect, what is it? Governance and meta-governance, to me is insufficient because you don't explain why this is direct or indirect governance or meta-governance. And I think you would basically need to give some more meat there. So you need to spell out the governance issues and the governance theory, and then you can look for criteria. So one, what you are basically treating, and I think this is where I think your hunch goes, is the question of remedies awarded by those tribunals. And all those cases basically rewarded what I call primary remedies. Okay? And this is what you call direct governance. Whereas the tribunals now usually award secondary remedies, meaning monetary damages, what you would call indirect governance. And you say, well, but that's less intrusive. Not necessarily so. I calculated it once when we had the cases against Argentina pending. The claimed amount of all cases at that point against Argentina amounted about 55% of the annual budget. 55% of the annual budget. That was about in billions. Okay? So that sovereignty cost can be pretty high. That got everything awarded, but you had to pay everything, but still, I think you need to be much clearer on that. And just in case, because I suppose you're in the group of Stefan Schill, in his book on the public dimensions of investment law, I have an article on primary and secondary remedies, and it's interesting if you see the arguments of countries as well, because it's countries oftentimes say we don't want primary remedies, they're too intrusive. Argentina especially said so, but then you have other countries like Germany who give primary remedies in settlements. That's what Germany did in the first Vattenfall case, right? They settled the case and they gave Vattenfall everything Vattenfall wanted.
Is the comparative public law?
Yes. I think so. I don't remember the time. Anyway, you'll find it. So then I thought, what would be other issues where you could compare governance issues? One is probably on the contract-based versus treaty-based arbitration, because this is all contract-based arbitration. There was no treaty-based arbitration. And giving a consent, a general consent of being sued to anybody who's investing in my country from a respective country might be more or entail more sovereignty costs. I call it sovereignty costs. Okay? Then the third thing might be, and that I don't know because it depends on the contract. I don't know those contracts, and you might not be able to figure that out from the arbitrations. Is the interaction between international and local remedies? And I think one of the issues why investment law is so under threat is that there is basically no local remedy requirement. And the fork in the road is basically wish-washed away by the tribunals. So, and there might be different, more issues which you might want to consider, but this would be the way I would go, because only that way you can make your point. It's not enough if you just state those cases, as interesting as those cases are. And then, I wonder, what Gus van Harten says, you don't want to build a PhD a word from Gus van Harten. I mean, you know, not that he's an important scholar, and I think he has been funnily, you know, much bashed for what he wrote, which is by now basically the position of all the states. Why is it the position of all the states? And I think that is something which is more important than just saying, well, historically states have agreed to that. What's happening now, and you might want to look at that. What happened, I mean, the attitude of the states which were building up investment law, the capital exporting states, changed as soon as the capital flows changed. And they got sued. And, you know, I was astonished that, you know, you don't have, Paulson has done, I think, very good research on the learning effect. And if I think about Germany, 2 anecdotes and then I stop, okay? 2010 I was at NYU and there was a Hauser fellow who was the government official negotiating the ITs. And I said, God, you know, tell my story, but I think our bits are not cleverly written. Why? I said, we might get sued. No, we will never get sued. I said, well, but the US gets sued. Yes, but they are not a rule of law state. I said, okay. No, I accept that argument. 3 months later, we had the first Vattenfall case. That wasn't enough to really change public opinion because it was totally kept out of the public debate. That changed with the second Vattenfall case. Now, what the German Association of Judges did, 1 minute, is offer a statement, the German Association of Judges, that ISDS is unconstitutional. Given that Germany is having the gold medal in having EITs, and we are having this for 60 years, it came late to them, it occurred pretty late to them that ISDS was unconstitutional in Germany. And you ask yourself how neutral they are actually. But what happened is they got sued, you know? I mean, you know, Germany got sued and suddenly, you know, the cases were taken out of their hands into the international sphere. But, you know, it's not enough to say historically that was also the case. And, you know, this Kelantan, you haven't explained it, but I looked it up in the footnote, and thankfully it's in the footnote because I was like, is this on the moon or is this? That was a province of Malaysia. Czechoslovakia was never a really strong state. Greece, unfortunately, one have to say, continues not to be very strong. So all those cases were against non-strong states. Now the cases are against strong states. And they're contradicting EU policy. If we have all the new energy, the new renewable energy stuff against Spain, Italy, the case against Germany, France's cases. We didn't care about the Czech cases. Even 15, 20 years ago, we didn't care about that. But we care if we think it's strong states, rule of law states, who get sued. So I wonder, you know, as I buy your story, but I wonder whether that is any argument for what's going on now to you know, to make people think. I don't think it will. Sorry to be pessimist here. Okay, stop here.
So we want to have a quick round of responses to, as I predicted, the numerous comments. Alexandra, please.
Okay, well, thank you very
Keep
much.
it brief so we can collect
Yes,
more
it'll be brief. So as I was writing the paper, it was within a very short time frame. And so I was writing it and I was cringing inside because I thought, oh, Anna's going to have to read this. But then I thought, well, you know, she's familiar with some of my work, so maybe she won't judge me too harshly. And she will know that, you know, this is going to turn out okay, into something that'll make sense. And I'd gone over it, and I was like, okay, what I need to do, I need to be clear on my theory. I need to be clear, like, so I agree with everything you say, and I'm sure that there will be more comments, but no, so great, thank you.
Wonderful, thank you. First of all, this was really super helpful for once because I am guilty as charged with 2 points, and actually one that I'm particularly sensitive about is that I'm not entirely sure what the nature of my paper is yet, and that's clearly something that I need to decide on. I need to decide on very quickly. Another things that I wasn't at all aware, or I mean, I was aware of the adaptation literature, but I haven't at all engaged with it. So that's another very fair point and observation. When it comes to the anti-corruption point, though, I have to say that I hint a little bit at this by talking about Weaver's work, but I haven't really explored it in full detail. Where Catherine Weaver published a book called The Hypocrisy Trap, and she explores how the rhetoric of the World Bank actually completely diverges from its actual practice and how it is necessary to legitimize the world of the bank in light of contestation. And part of the things she takes on is Wolferson's anti-corruption agenda. So I think I do need to incorporate it more into my thesis because now it's not entirely clear. And then another thing, and here this comes a little bit back to the nature of my paper. It's not an affirmative claim. I'm not saying there are no other variables, and you're completely right. Obviously, there are so many other variables that could come in. But I chose to focus on this one.
It hasn't been said yet.
Yeah, it hasn't been said yet.
Thanks for all your comments. It's very useful. Yeah, I mean, I cannot address everything, but yeah, I definitely agree that sometimes monetary sanctions can be, or sort of monetary remedies can be much more impactful and prohibitive than, having like a direct order to do or do not something. I'll perhaps just address the final point. So I know when like lawyers do history, it's always kind of, so what does it mean today? Like, what can I learn from this? Like, that is really not my kind of goal. The goal is to see how it was, not to see how it was so I would know how it is today. In a sense, like, I mean, when we're talking about my sort of PhD. So the first point is just like to explore what happened before, and then I do think we can learn something from that, but it's not necessarily the purpose of doing it, if that makes any sense.
No, I think my main point is really trying to find more criteria on which you say it's different or it's the same from a governance perspective, right? I think that is really my point of the structure.
Okay, thanks.
Okay, so the floor is open.
Wow.
Okay, good. So let's collect a few. So Tal, yeah, we'll just move from left to right. So the first three, ending with Liz. Go ahead, Tal.
Thank you very much for the presentation and the comments. I learned a lot. Vladislav, I wish to continue one of the critics raised by Anne. The issue of governance. You give a very specific example of a very specific context of a decision which deals with a very, very, very particular situation. And when I think about governance, I think about something which is much broader and which entails more responsibility to a much larger extent. So I agree that this is a problem in the ability to extract from one very specific situation something which deals with a phenomenon which is general. And to make my comment more productive, I think that actually permanent courts or permanent bodies are more suitable to be attributed roles of governance. The ECHR is one example, but if you want to look at history, then the historic example I would have thought of is maybe the PCA, the Permanent Court of Arbitration. When you have a permanent body which deals with specific with issues, especially the ECHR, which deals with a regional situation, but also the PCA, I think that it is more appropriate to attribute to it the role of governance. And in relation to Alexandra's presentation, I'm not sure that there is any advantage to collective sanctions, because in practice we see that the problems with individual sanctions also exist in collective ones. For example, selectivity in the application. We can look at the sole two examples of using sanctions against Iraq, but no sanctions against the US in 2003 and against Russia in 2014, etc. On the legal level, I think that in general, international law does not regulate individual sanctions, and the most we can say about it is the Lotus Principle. If you violate something else, non-intervention, a human right, if you have an obligation, then you might have any legal significance. And in this regard, I think that collective sanctions have more probability to violate international law. Because if one state decides on individual sanctions, it will have an effect. But it will not have the same effect as we can see, for example, now in North Korea, when we have collective sanctions. So I think that and I'm sorry that it's been long, I think that collective sanctions have more ability to violate either the principle of non-intervention, which is the most basic possible violation, but also in a more advanced understanding, for example, of human rights. Okay, so when people are starving in North Korea are the states which apply collective sanctions violating human rights law. So I think that we have even more legal problems in collective, and I think that the discussion should be on both. I think that we should not differentiate. I think that a discussion of both individual and collective might actually be useful to the understanding. And I'm sorry, I'm not using anything.
Thank you. Please.
Thank you. I have two questions directed to Alexander. The first one is fairly technical. Now, some of the measures that you're discussing, in particular regarding Crimea, are not really countermeasures in the sense that they are enforcement measures. And I'm thinking about the measures that the EU and others are taking in order to ensure that they are not assisting the illegal situation in Crimea. Of course, this is a quite technical difference, but does that make a difference from a perspective of what you are researching? That was my first question. The second question was that I think it's a really interesting research project. And perhaps this is beyond the project, but I'm interested in what is the outcome of this sort of process of contestation and so forth. So is there a third coming out of it or not? Perhaps sometimes it's helpful, to force the target states and their allies to articulate their positions on various issues. So let me take another example from a slightly different field, but still got something to do with sanctions in the wide sense. It's aimed at international criminal justice in Africa. So the uses of universal jurisdiction and the various constitutions by the ICC have prompted Africans to take certain measures. I'm thinking about the ESIL case in Senegal and also the decision to widen the jurisdiction of the African court to cover criminal issues as well, although I understand that it's not operational. But these are the steps that have been, that they have taken as a response to what they think is politically at least legitimate. Thanks.
We'll take one more, please.
Yes, my question goes to Vladislav Janik, and it relates to the setting of your whole argument. I mean, you depart from the point of view of social movements and the criticism that comes from them for investor-state dispute settlement. And you say that they have a perception of novelty, but I would say that that's uninformed radical movements, but those that are more serious, that are well-informed, that are specialists, in their criticism, they depart from two things. The lack of a right to regulate by democratic states environmental issues or to change legislation if there is a change of government. And the second main argument of these NGOs is the private origin of the arbitrators and the conflict of interests that usually arise in private arbitration. That's what you find when you go to talk in seminars organized by these NGOs. So as regards to the right to regulate, it's really the legitimacy of this method of dispute settlement is mainly addressed to these points. I mean, it's when you have a democratic parliament that chooses to change the legislation, these may be taken as going against the principle of equitable treatment, and therefore an international tribunal will caution or say that you have to give a lot of money to that private company. You have mentioned, Anne, the question of the renewable energy cases that more than 20 of them against Spain because of the measures taken in 2010 when there was a huge budgetary crisis. The salaries went down by 10%, the price of housing went down by 50%, so there was a huge rebate in public spending. But the only people that will not be affected are the foreign companies that invested in renewable energies. Because as there was a radical change in the legislation, that kind of radical change very well fits into the definition that you find in investment case law as non-equitable treatment. Doesn't matter that it was general on health cuts, on education. So it fits in there. So the people that have suffered such a budgetary cuts, that have suffered such a crisis, and see that the parliament, the democratic parliament, was not able to change the subsidies given to the electric companies, protest. And as regards the second argument, the private origin of arbitrators, yes, of course, we have heard a lot about conflict of interest, the arbitrator that is one day judging the case and the other day judging the same arguments, but as defendant of the private company, that he would have to interpret the following day again as an arbitrator. And obviously, as you have said, private public courts, permanent courts, could help to solve this problem. And this links to your argument on meta-governance, but it is not directly addressed as such, as far as I have heard. So I would say that if you depart from the criticism coming from the social movements that go against these disputes of procedure, you should pay perhaps a little more attention to this interpretation of the right to regulate and this meta-governance problem of the arbitrators and the arbitral system.
Do you want to respond to the
If there's no other questions, sure.
No, there are other questions, but I
I can respond. Yeah, thank you for these comments. Of course, there are other issues that raise legitimacy concerns. I'm not saying that this is the only one. So, of course, those are also relevant. But I think, like in terms of public courts having the ability to exercise this governance law, sure, we can have them. That will not mean we don't have investment arbitration. So, even if there's a multilateral investment court established, that doesn't mean that investment arbitration will stop. So, courts can have the same governance role. Maybe they can do it better, but that doesn't mean that this goes away. So, I don't think that just like pointing to courts can be a solution in this respect. And then that brings me to your comment. So, you say that when you think of governance, you think of something else. That is precisely my point, that this is not one concept that needs to be more differentiated, and we need to see it that there's different aspects to it. So, I think that's kind of just what I was trying to explain. Again, the PCA, I'm not sure I would qualify that as it's a permanent institutions, but the tribunal that act within the PCA are ad hoc tribunals. So, I don't think that they're in that sense necessarily much different from other tribunals.
I gave you the ECHR as an appropriate example, but I heard that you want to focus on history, so that's the only other historical example. I wanted to give you something.
So, but again, if they establish the EU is now working on it, if they establish a multilateral investment court, this probably gets magnified because you have then a permanent court that is always interpreting the same people, interpreting the same. So this probably gets more intense. But I don't think that resolves the issue because, investment arbitration will not go away because there's a multilateral court, because companies can always agree to go to arbitration with states.
Public interest will be taken into account better by a public court.
That may be.
But I don't think that's in your page.
This is
this isn't one of. It's a different debate essentially. The question is, how does yours? How could it feed into the debate? Do you want to respond?
Sure. I'll start with Tom. So, you're right. So it's collective sanctions. It's what I call multilateral sanctions. The same debate, but my PhD is limited to unilateral coercive measures. The groups that I was referring to that protest against UCM also protest against what they call abusive Security Council sanctions, and they are very highly critical of the measures that were taken against Iran, against Libya, and they accuse them of double standards. And because of the catastrophe that arose from Iraq, I'm sure you're aware, we transitioned to targeted sanctions. But what I was referring to as well is that, we see regional groups like ECOWAS or the African Union take sanctions against their own member states.
Under Security Council authorization. Not
No,
under
no, sometimes they take it, you know, that like.
Mali was under Security Council.
Yeah, but for example, Burundi, that was not under Security Council authorization. But you know, like that's just to say, like that's a different type of practice that I haven't analyzed, and so I'm not sure to what extent those types of sanctions fall into their criticism. Since it's important to be precise, you know, because people always say yes, but this sanction worked, and this sanction, you know. So anyway. And then, yeah, in reference to the fact that sometimes sanctions are adopted in order to not recognize illegal acts, so that's Article 42 of the Articles on State Responsibility. So legally, that makes a difference because, you know, what you were saying, it's the Lotus Principle, so then when I analyze the sanctions in legal terms, you know, you want to know, is this an act of extortion? Is this an internationally wrongful act? And if it's an internationally wrongful act, can it be justified as a third-party countermeasure? But I mean, I excluded the legal analysis here, but like legally, that does have implications. Whether or not that has implications on the effectiveness debate, I haven't considered that, but from Russia's perspective, all sanctions are equal. So, I mean, Russia doesn't distinguish between, you know, I'm being sanctioned under Article 42. I mean, for Russia, it's just, you know, this is unfair. So what is the outcome? You know, what I believe the process of stigma and contestation, for me, I view that as like a process of negotiation. So these states are negotiating what they view as the international legal order. So what's the outcome? I think there's an interesting shift happening, especially with Russia becoming more and more assertive and, you know, aligning itself with other countries. So I'm curious. But what I think is that we should move away from coercive measures to peaceful settlement of dispute mechanisms. And the example you gave is interesting because those measures were taken by the African states, and it was especially a judicial process between Belgium and Senegal, you know, where an erga omnes obligation was at stake, the prohibition of torture under the, Belgium argued the treaty obligation, not the customary international law obligation, but like that's an interesting example of how here it's a judicial process, a peaceful settlement of dispute mechanism that led, you know, that way, and it wasn't sanctions. So yeah, so there's interesting venues, definitely.
So second round, we have about 10 more minutes.
Yeah, so my question is for Alexander. I thought it was a fascinating paper. It's a really interesting area of the law that you're in. My question is, I would be interested in hearing your thoughts on the phenomenon you describe in terms of legitimacy. I mean legitimacy in terms of the kind of political theory about the necessity of it as a central buy-in mechanism for the maintenance of legal order. So going back to Max Weber, Thomas Frank has written about this in terms of international law as well. Because it seems to me the phenomenon you're describing is a particular manifestation of not a crisis perhaps yet, but a problem of legitimacy that the international order faces, that the unilateral sanctions from, say, the US, Europe, etc., that are occurring are essentially projections of global order. These states and entities are acting as representatives of the policemen of the world, essentially. And that this is what ultimately the states are having a problem with, is that they don't want to live in that particular world anymore because it feeds into the narrative, the in-groups and the out-groups that you talked about, or the imperial narratives of, say, the zones of lawlessness being requiring a standard of civilization, requiring the salvation of the white man or whatever. So I'm wondering, to the extent that this is perhaps less a legal problem than it is just an overarching political problem about the legitimacy basis upon which international law is built.
Yes, also to Alexander, you're getting a lot of fire. I'm wondering about can you expand a little bit about the proposition that sanctions are a norm? This is something that I'm having some normative difficulty in the sense that if it is a norm, the question is then do we need to evaluate it for a norm? Do we have like a Fullerian internal morality lens through which we should explore whether it is so if it's a communicative norm which is supposed to stigmatize, you then get into the internal contradiction of a norm which doesn't meet certain internal morality criteria, is not effective in generating the communication. I think that goes along the fair sanction point that was made by Anne. So I'm wondering, however, is there a way out? Because you said something like, this is the area in my paper which is a bit gray, and I'm wondering if it's not a norm, what is it? And if it is a norm, is it really a norm? If you have an internal morality criteria. Secondly, would the same analysis apply to unilateral measures applied by non-state actors? I mean, you focus a lot on state sanctions, but we have a parallel discourse about sanctioning by non-state actors. The whole boycott movements, etc., divestments. So these are, that's another set of issues, and the question is, maybe you don't have to answer on the spot, but I think it would be an interesting comparison perhaps to make. And finally, I was not fully, maybe I didn't fully understand the point about fragmentation. I mean, the example you gave was an example where a state is being accused of violating a certain norm and then makes the proposition that the sanction violates another set of norms. But I'm not sure that this is in itself an example of fragmentation. I think a case could be made that human rights norms, in this case, trump the general non-intervention principle, etc. So this is just a question about conflict of norms and perhaps some different conclusions about how these conflicts should play out. But it's not this. It doesn't have this quasi or fully self-contained aspects that you see in other fragmentation area where you have a court that can only look at issues from a very tunnel vision perspective and therefore cannot look at. I mean, I don't think there's a serious argument that the U.S. is not aware of the UN Charter when it is imposing these sanctions.
Yeah. Okay.
Anyone else? Because I'll just maybe add something to Vladislav on the, because I'm also having difficulty. First of all, I think I'm definitely got right the sort of historical narrative, and you're referring to David Paulson. You haven't read my latest paper with Johan Mafte, in which we actually prove that states do renegotiate on the basis of their experience. In other words, there's a very strong empirical correlation between ISDS experience of governments and then how they renegotiate and revise and recalibrate their agreements. But I'm also having difficulty with your historical analogy, because essentially these are all contract-based disputes that happen to reach international arbitration. So I don't think there's anything novel, or that anyone thinks that there's anything novel with investors having disputes with states, right? That sometimes also have regulatory costs, because it's just that often they would be settled in the domestic arena, which presumably might be more legitimate. But that's one reason that we have ISDS, because investors weren't necessarily very happy with the results. So there are other issues as well. I mean, the regulatory costs of ISDS are much amplified by chilling effects, because the similarity between the investment protection provisions. So let's say plain packaging. Philip Morris files against Australia. No one adopts plain packaging legislation until the dispute is over, and also in the WTO. So that has this sort of ripple effect that I don't think you can identify going back to the 1930s on a contract basis. But so do you want to respond to that?
Do you want to go first?
A couple of minutes.
So first, thanks for this tip. Yes, they are all contract-based. But to me, that is precisely the point, because the narrative has been this treaty-based has been completely new. We haven't been seen before. It's completely different from commercial arbitration. And what I'm kind of trying to show, no, it's not. So if you do away with it, a lot of the parties will just go back to commercial arbitration. This will continue happening.
Brazil,
and you will not know about it because it's confidential. So I do think that in terms of thinking of what we should do about it, if we want to reform it, it is relevant to know that this is not something you just brush away by getting away with treaty arbitration. So on that point, that was one point I was trying to make. In terms of the ripple effect, of course, that is kind of also what I'm trying to ask is like, what? So I'm not saying it's the same. That's precisely like trying to show what is different. But for example, to show you that there was also some kind of ripple effect, there was another case that I discussed in the paper that's also involved Radio Corporation of America. That was against China. So the first Radio Corporation of America versus Czech Republic was solved, and then I was kind of like nothing was happening. And then there was the second China case, which Radio Corporation of America lost. And it was only once it lost that case that it actually went back, and kind of the issue with Czechoslovakia was definitely solved. And what happened afterwards is because the Radio Corporation of America was operating in 40 different countries with different national operators, it used the China decision to inform all of the administrations in different countries of that decision and how kind of the relationship with those administrations going forward should be based on the pronouncement of that tribunal. So I do think, I mean, of course it's not the same as you have in investment treaty arbitration because it's a different level of generality, but I do think that sort of, yeah, it's not like this has not happened before.
Yeah, 1 minute.
Okay. All right. So I'll just start with the legitimacy problem. So yes, I would say. And the thing is with sanctions, I mean, to much said, I hate sanctions, but at first, I've grown to love them because they're like the Russian doll. You know, you keep unpacking it, and then it just becomes smaller and smaller. And so when you get down to it, yes, I'm really like on the cusp of the legitimacy problem in international law, and then like how do you address that? And for me, the issue is that we kind of conceive, in my view, we conceive of international law in the wrong way. Or we conceive of sanctions in the wrong way. Because we all accept that international law is a horizontal system. But then we think that, in order for law to be law, it has to have sanctions. But sanctions are vertical. They're not horizontal. So maybe if you want to solve the legitimacy problem in international law, you kind of have to reconsider, how do you enforce international law in a horizontal system? So this is just a preliminary point, and that's just kind of where I'm going to. So I don't know if that answer makes sense. So I kind of think it's more an idea of changing our perspective of it than, in trying to make reality think. Instead of making reality fit what we think it should be, we should just say, well, we're in a horizontal system, so, let's shift more towards something that way. So sanctions as a norm. So I guess, I wasn't clear. So the idea is that when states adopt sanctions, they're signaling that in their perspective, this is a norm that should be upheld. And so when I said it's a gray area to me, I agree with what you're saying, that if it's not a norm, then what is it? It's just that I hadn't developed my thinking in order to make like a sound argument. So it's just more research in order to defend that theory of mine.
So it's a tentative.
It's a tentative,
It's an emerging.
but I'm not being.
No, I'm confused. You're talking about a different norm, right?
Yes,
Alexandra is talking about
The norm is being
uphold the norm which was presumably violated.
That's what
So there's
I'm talking
no
about.
second norm.
So I'm thinking of the second order.
Exactly.
Yeah, so-
About sanctions.
Yes.
So if sanctions, there's two levels. So it's
So I'm
upholding the
assuming
norm that is, it's upholding the norm that has been violated, and then the fact that they're adopting sanctions, it becomes a debate of whether it. So the debate isn't about the norm that was violated. The debate is about if this is an appropriate enforcement mechanism. And so then I do agree with what you said. It's not about a conflict of norms, but a conflict of how to enforce the norms that have been violated. And the reason why I call it a fragmented legal order is because the conflict of how to enforce international law, for me, it's like a mirror of international society, but of how states expect each other to behave in their international relations, if that makes sense. So for one group, it's appropriate to adopt unilateral coercive measures, and for the other group, it's inappropriate, and more focus should be on multilateral or equal footing measures. I don't know.
It's maybe fragmented argumentation.
Maybe, yeah. I'll review that way, but yeah.
Okay,
Thanks
so-
for pointing that out to me.
We've made it so far without any disorder. Have a vertical shift downstairs. Please join me.
Yeah.